Hello everyone, welcome to LawPutra's YouTube channel, and the concept which we are going to study is ratio decidendi. But before talking about ratio decidendi, we need to understand why do we need this. If you all know, in India we follow doctrine of precedent. The groundwork of this doctrine has been laid by Article 141 of the Indian Constitution, as it provides that the law declared by the Supreme Court shall be binding on all courts within the territory of India. In general parlance, precedent is a statement of law created by a judicial pronouncement, which is a binding principle that could be adopted or taken as an example while deciding the subsequent cases with similar material facts. This video is basically concerned about ratio decidendi, so we will talk about it now. When giving judgment in a case, the judge sets out the facts, states the applicable laws to them, and then provides the decision on the matter. It is not all the aspects of a judgment that are relevant to determining the principle decided in the court. However, the other parts of judgment are not entirely useless. Accordingly, the decision or judgment of a court may fall into two parts: the ratio decidendi, reason for the decision, and obiter dictum, something said by the way. A good understanding of what constitutes ratio decidendi and obiter dictum is therefore very critical in determining what constitutes precedent. Just suppose a decision has been given by a superior court. Will that whole decision be binding on the lower court? No. Only the reasoning part of the decision will have binding value. That reasoning part of the decision is called ratio decidendi and is binding on the lower court, whereas that part of decisions which do not have any binding value but have only persuasive value is called obiter dictum. The dictum and ratio were distinguished in the case of Director of Settlements AP and others versus MR Apparan and other, as dictum is the observation of court on the arisen legal question which may not aid in attaining the decision of the case at hand, and the same has been stated in the case of State of Haryana versus Radbi. Ratio decidendi. This Latin term literally translates as a reason for the decision. The ratio decidendi of a case is a principle of law on which a decision is based. When a judge delivers judgment in a case, he outlines the facts which he finds to have been proved on the evidence. Then he applies the law to those facts and arrives at a decision for which he gives a reason, ratio decidendi. Note that the ratio decidendi of a case is not the actual decision or order, like guilty or the defender is liable to pay compensation. Rather, it establishes a precedent, which is a rule of law used by the judge or judges in deciding the legal problem raised by the facts of the case. This rule, which is an abstraction from the facts of the case, is known as a ratio decidendi of the case. Let's just take an illustration of ratio decidendi. Assuming that a couple leave the dog in the car while they pop out to a shop. For some unknown reason, the dog gets excited and starts jumping around. The dog paws the rear glass window, it shatters and a fragment of glass flies off and unfortunately falls into the eye of a passerby who later has to have his eye removed. Are the couple liable to pay compensation for the man's eye? The court said no. People should take care to guard against realistic possibilities. They should only be liable, the court said, if they caused others harm by doing something that could be reasonably foreseen as likely to cause harm. We are not liable if we fail to guard against fantastic possibilities that happen to occur. The accident in this case, the judge's rule, was just such a fantastic possibility. The couple therefore did not have to pay compensation. The reason for the decision in the case, the ratio decidendi, can therefore be expressed simply as where harm was caused to a pedestrian by a dog smashing the window of the car that it was in, and where this sort of incident was unforeseeable, the defendants were not liable. Similarly, the ratio in the case of Dono versus Stevenson would be that a person owes a duty of care to those who he can reasonably foresee will be affected by his actions. Finding the ratio of a legal decision is not an easy task to be performed, as a margin between the ratio decidendi and other interpretations of law, like dictum, is slightly obscure. So, some of the principles or methods to ascertain the ratio of a case are as follows. First is classical or abstraction method. The process of abstraction from all of the facts that occurred in the case is necessary to determine the ratio decidendi. The ratio decidendi widens as abstraction increases. Second is reversal test. Professor Wambach says that we should take the judge's legal argument, negate it, or invert it to determine if the result will change as a result. If so, the proposition has a ratio component. If not, it does not. However, this approach will be useless when there is no proposition provided or when the code provides multiple justifications for its rulings. Third is material facts theory. According to Professor Goodhart, the ratio decidendi is simply the judgment made based on the relevant facts of the case. The earlier case is a precedent in point if material facts in the later case are the same as or agree with those in the earlier one. But the theory is overly straightforward. By using alternative combinations of relevant data, different ratios can be calculated from a decision. As a result, there may be confusion and disagreement over the ratio of a given decision. So this was all as far as ratio decidendi is concerned. Hope you have understood the topic and liked it. Thank you.